Question. An employee files a discrimination case against a co-op or a condo. Can the co-op or condo disclose the name of the employee?
One of the major issues are, and I will give every board member their Miranda warnings. What you say, what you write, what you email can and will be used against you in a court of law. One of the major things is if you advise your shareholders that there's litigation via an employee, it would necessarily mean that we've disclosed it to our group, and I believe that we are entitled to disclose it to the shareholders, but I do not recommend it because of the potential for the employee to claim there was retaliation by giving out his name. I don't think there's a specific prohibition or any specific type of gag rule in effect from a court or from the judicial panel that it's before, whether it's human rights or some other union. But I do not recommend that the board disclose that at this time, albeit I think the board can give information about the litigation and may not necessarily need to disclose the employee's name. I'm going to defer now to Steve and to Dan.
I think that I agree with what Ron said, and I would just add to that I think this is a example of what we're going to deal with a lot of these questions, which is the difference between can and should. And just because you can do something doesn't necessarily mean that you should do something.
Can the board disclose the names of shareholders or unit owners who are in arrears? So,
I mean, this one is kind of a little bit of a trick question because I'll answer this. To me, the answer is no. If it's at the beginning, if you're talking about a managing agent's report showing arrears, that I would say no, they can't disclose it because they don't really know. There could be extenuating circumstances, there could be explanations, the managing agent could have made an error. You're not talking about a judicial determination that somebody was in arrears. So I think it's very dangerous to do it at an early stage. If you're talking about a later stage where you're either in a proceeding in court and you want to disclose that you're in court, I guess you could. If you're talking about if you have a judgment against somebody, then it becomes a yes, you can. Again, whether you should or not is a little different, but so that's how I would answer this one.
Ron, comments?
Sure, it's basically the same answer that I gave before. Do I think that you have the right to do it? I think the board has the right to disclose it. I do not recommend that they do it for the same caveat that Dan just said, and especially under the guise of the Fair Debt Collection Procedures Act, as well as the Fair Debt Reporting Act. I wouldn't want to put somebody in a position where they're not in arrears or there is a question, they're disputing the accuracy of the ledger. I do not recommend it under any circumstances that it be done.
Steve Lasser, your thoughts, please.
I have some buildings that have some arrears issues, and they try to be as aggressive as possible. At least one of my clients does post same list in the common areas, and I would say it has mixed results. I think some people who aren't capable of paying are not going to pay just because you're flogging them. That doesn't necessarily achieve the goal. And to sort of go along with what Daniel and Ron were saying, you run a risk if the numbers are not accurate. You're libeling someone, you're posting incorrect information, defaming them. So I would just say, proceed with caution. If you're sure that they owe money, I wouldn't put the exact amount. I would just put that they're in arrears. I do have some clients that do that. I think you can do it. Whether you should, I think it's a different issue.
One of the issues, Jeff, is should the names of the people in arrears be disclosed in the monthly minutes of the board? I like to have a separate list of people that the board are discussing, or if minutes are to be disclosed or sent out to the shareholders, I like to redact those minutes to delete the names of those people who are in arrears.
3, can the board exclude a member known for indiscretion in revealing confidential information from the discussions of sensitive issues?
I would, okay, so if you're talking about at a meeting of the entire board and it's just a general board meeting, anything discussed there, I don't think you can just exclude somebody. Having said that, there are ways of excluding somebody. A board can have a meeting of just the executive board, which would be president, vice president, treasurer, secretary. So if the person that you want to exclude is not an officer, then you could have an executive session, have a meeting of just the executive board, and then they would be excluded, but so would anybody else that is not on the executive board. So that would be how I would answer that.
Ron Sher, you're next.
Yeah, Dan and I, in fact, discussed this with Steve about board members are elected. Board in and of itself cannot excise somebody from a board, remove them without a vote or a supermajority vote of the shareholders who elected them. But during a meeting, as Dan said, if you have a person who is a problem, you can, in fact, remove them as an officer, make them a regular board member, and then, as Dan said, adjourn to executive session. I agree with Dan at 100% on that.
Steve Lasser, your thoughts, please?
Yeah, I'm in agreement on that one. I think that, yeah, there are ways, as Dan and Rod had indicated, to try to exclude someone going to executive session. And as Ron had indicated, presumably the person was properly elected either by the shareholders or the board in a lapse of judgment, inadvertently pulled someone on the board that has loose lips to fill a vacancy, put someone in that position. And, you know, unfortunately, when you have a situation like that, you can strip someone of their title to remove them as an officer, but to remove someone from a board is going to require a vote of the unit owners or the shareholders. And, you know, that can be very dramatic and adversarial, sort of bad for the community. So, you know, I think it creates a problem. Unless the person's really bad, you're probably not going to go that route. And it's a difficult situation that I think a lot of boards encounter. I know, you know, one of the things that Ron was thinking about talking about was, you know, disclosure or non-disclosure agreements and, you know, codes of ethics. So that's another way to approach that. I don't know, Ron, if you want to add to that.
No, in fact, before I would go into executive session and strip the person of their officership, I would clearly speak to them in advance. I would tell them, we believe that you've breached your duty as a member of the board. You're revealing confidences of what's happening here, and we feel uncomfortable. If you don't cease and desist, we will have no other choice but to do this. I would not just do it without their knowing. I would give them fair warning. I would ask them to act in good faith going forward, and then after they fail to do that, I'd have the minutes reflect something or send them a letter that this is what we're going to do, and I would then do it, especially if you as a board feel that their conduct prevents you from acting in the best interest of the corporation.
Can the boards disclose which vendors are bidding on a particular contract?
I mean, yeah, I think they can. The only thing that I would say is it kind of depends on when you're talking about in the bidding process. If you're getting sealed bids, then you wouldn't really know until after you've gotten the bids. But you know, it's part of the books and records of the corporation. So I don't really see why not. You know, again, it is a question also of can versus should, and at what stage. But I don't see why not.
On Sher?
I think the board has the absolute right to disclose who is bidding on a project. As Dan said, if they're sealed bids, I wouldn't disclose the amounts of the money. But the question is, can a board disclose which vendors are bidding? I think the board has the absolute right to say that we are accepting bids from these contractors, and our managing agent will be giving us a summary of those bids, and the board will be reviewing and putting together a determination of who to approve. There's no problem with that. And in fact, just as an aside, board members who have an interest in any contractor, if they're an interested director, as you all know, on an annual basis, you're required to disclose that you had an interest in that contractor, and that you have a financial interest, a familial interest, or that you are involved with them. So the disclosure of who contractors are, I don't see a problem with.
Steve, I'll ask you your thoughts, please.
So like a lot of these questions, you know, whether you should or whether you can, you know, there's two sort of different issues. And I think, you know, it's always good to have transparency, but as a board, you still have to function properly. And I can tell you that, you know, we have had projects where there are people who think they know more than the board, or they're experts in some area. And obviously, if they're legitimately an expert, then they have a great contractor that they want to bid on the project. That's, you know, that would be welcome. I think sometimes, you know, too much information can sort of lead to distractions, where, you know, people are elected to serve on the board. They've hired professionals. They're doing a vetting process. And, you know, you don't want people that are not on the board. You want them to be fully transparent with them, but you also don't want to open up a situation where there's an open dialogue necessarily with the entire building giving their input project. I mean, you can get everyone's input, but I think ultimately the board was elected to make decisions. That power, you know, lies with the board.
Can the board disclose the condition of a popular maintenance employee who was out sick?
It's probably not a good idea. I think it depends on the circumstances. And I think Ron was alluding to some COVID issues. I'd be interested to hear how he addressed those issues specifically. I don't know that I had to deal with that with the building super and COVID. Ron, if you dealt with that issue, I'd be interested to hear what you.
Unfortunately, I have on various buildings, and in fact, the managing agent asked, "What should we be doing?" And it was, at first, we were sending out notices that an employee had got COVID, and that the building is taking the necessary precautions to clean the areas where they were. We, in fact, had notified some of the shareholders that the porter or whoever it was in their apartment, or that they had been in close contact, or people in the gym or wherever else, or a concierge had met with them. And at certain times, we felt there was a necessity to disclose who it was. But it's a similar position with, what do you do with bed bugs when bed bugs are a condition in a building? And do you disclose to all the shareholders that there's a bed bug condition and which apartment it's in? I think that from my standpoint, we do disclose there's a bed bug condition, but we don't disclose where it was, but we only indicate, as we do with a sick employee, that we've taken the necessary steps, made the necessary arrangements to protect the shareholders. Dan, I'll go back to you and Steve.
Yeah, I again, this is a can versus should. The should, I think, is protected under the business judgment rule, but I think you certainly can. And somebody posted, this is a HIPAA violation. It's not a HIPAA violation. HIPAA, we talked about that. HIPAA has to do with disclosing medical records, and really medical providers disclosing medical records. It doesn't have to do with if a co-op board becomes aware of something, whether they disclose it to their shareholders, unless they sign some kind of confidentiality agreement or some kind of agreement not to disclose it. But barring that, there's no, there's nothing that says that they can't disclose it. And depending on the circumstance, maybe, and especially with COVID, I think there may be a good reason to disclose it, and I think that would be just covered, like we said, under the business judgment rule.
But you're wrapping this question all around COVID and not in a general condition. So let's not think about COVID, and let's think about life in general.
Let's assume the super is dying and has a
And he has cancer,
carcinogenic condition.
right?
Should we disclose it? I mean,
No, it's none of our business to disclose that.
let's
Well,
assume
that's,
the
that
super is out.
becomes a
is out of
board
work.
decision. That's a board decision as to whether they think they should or not. But if the question is, can they, it's not a HIPAA violation. They certainly can disclose it if they feel that it's necessary or they feel that it's a good idea for the shareholders to know. You might be right. You probably are right. That in that circumstance, it's probably not necessary. It might be nobody's business. But that, again, is a different question of the can versus the should.
So
Can the board disclose the name of a resident who has vandalized the property?
Have they just been arrested or accused, or have they been convicted? I would say the board, again, the board can, but if they haven't been convicted, then it becomes a question of should they, and it's dangerous to disclose names without a conviction or because then if you're wrong and they're not convicted, then you expose yourself to, the fact that you might have libeled them or slandered them. And that becomes another issue for the board that you might not want to be involved in. But as far as the can, yeah, I get you can. There's nothing to say that you can't.
The interesting thing is if the employee was fired for, let's say the employee got suspended, fired, or there was an issue for whatever the claim was. I think that the board could indicate Mr. X is no longer employed or he's been suspended. You may or may not want to or need to disclose the conduct that caused it. But I agree what Dan indicated with me. I would be very careful. A mere arrest is only an accusation and is not proof of something.
I mean, it's again, can you or should you? And then also, what's the purpose that it serves? To publicly sort of shame this person. Maybe there is a purpose. Maybe the person is a troublemaker and they should be publicly shamed. I think, it depends on the circumstance. As Dan and Ron said, if it's just an accusation and there isn't hard proof, you have to be careful. You don't want to lie to